So decoding complex contracts, that is the topic for the day. What we have when we look at a contract, we are often stunned by the size of it, the length of it, the context is not clear, and we start to judge the contract, and either it becomes too boring for us, or because of the perception that we've held, it becomes impossible for us to read into and understand. My first tip for the day is that there is nothing like a complex contract. A complexity of a contract is only a perception. The contracts, they are not complex. It's just the way that you want to identify the manner of reading the contract becomes the problem, and that's why you feel that it is very, very complex. So a contract can be lengthy, but that should not be your point of judgment. So as advocates, if we were to look at the number of pages that the book has, then we would never be able to instrumentalize this particular profession at all. So do not judge a contract by the length of it, number of pages. I often hear, very, very renowned advocates quoting that wo to 600 page ka tha. That's not how advocates talk. That is how a layman speaks. Because for him, 600 pages means a lot. For us, 600 pages may say there are only 60 pages which are crucial. And we should be able to identify only that, because nobody is going to sit and write 600 pages of something which barely makes sense. So we need an eye to identify which exactly is the parameter of the contract that we want to look into. And today I'm going to share a few parameters with you. Sometimes what happens is the contracts are very concise. They are not very, very long, but they are way too technical to be understood. So that again, the solution for the same is a little bit of research as to what is the transaction, who are the parties, what are the respective businesses, and what is the purpose of the contract. So these basic things, when you know, then the technical parameters are something that you can take help from Google also to understand, or from say an executive engineer or someone in-house would also be able to explain you certain technical aspects. But again, our point is not about the technical, our point is about the legal. It's important to understand the technical to link it with the legal aspects of the contract. Today, we'll understand how to read a contract that usually scares you by its length, language, or context. So today, as for the day, this is going to be our agenda. So the first tip that I have is know the purpose. As I said, you should have a background about who are the parties that are entering into a contract. So if they are say, for example, a service provider and a company, or there are two companies who are coming together for a purpose, or they are, manufacturing company selling its product, or whatever the arrangement may be. Is it a joint venture? By the title also, you can understand a lot of intention. Is it a joint venture? Is it a partnership contract? Is it, like a service agreement? Supply contract and investment contract, or marketing partner agreements where there is a person serving as a marketing partner for another. So by the title, you would be able to decode or understand the intention, basic intention. Know the reason why the contract is to be executed. Know the transaction, the commercial arrangements. All of these things you can take as a gist from the person who is allotting you the work. And if they do not know this, and it's a directly the assignment has been given to you, then what you could do is you could write these as a form of question on a piece of paper or in your diary, and try to find your answers while you are reading the contract. First, only find answers to these basic questions. So I believe and I feel that once you start reading a contract which threatens you by the length or the complexity of the language, you first decide to read it for at least 2 times. Okay, and in the first time, you answer the basic questions which we are going to understand, and then the second time should be the screening, where all of your basic questions are answered, but you are only cross-checking whether they make proper sense into the sentence that they have been inserted. So knowing the basic outline of the transaction is very, very important. And if you cannot know that before starting the contract, then no problem. We have other methods to get into the details of it. So first things first, you should read the index. when I was in my law school, I was taught that, a lot of the laws, you will be able to remember, not by reading the law actually, but by memorizing the index. That makes more sense because you have the chapters which are bifurcated into a lot of things. Same applies for a contract. When you have a complex contract, it's usually going to be bifurcated into many, many segments. There are going to be some major segments, then the sub bifurcations and the bifurcations, and then the clauses. Don't scare yourself by, like if a clause number reads 3.2.2.1.1 or something of that kind. It's okay. Just read the index first. You will know, once you know the index, you will know what to expect in the clause. So a careful reading of the index will help you a lot in, it will go about 30% on the way to reduce your anxiety into before venturing into the contract. So not only should you read the index in the beginning before starting the contract, but you should also read it before starting each clause. That will give you a perfect view of what to expect in that particular clause. Because when we sit down for reading a contract, we are usually distracted by a lot of things. So a preliminary index reading will not give you a fair share idea when you are actually reading the clause. So when you start a particular clause, you should ensure that you go back to the index section and read all of the things that are included in that particular segment. Most important, you should sit with a pen and a diary. Whenever reading a contract, sit with a pen and a diary and take notes. Now, what you are supposed to note is what we are telling. So I'm hypothetically taking a situation where there is a contract for, say, supply and product supply. And at a conspicuous clause, you've come to understand that the contract initially begins with issuing of a purchase order. Okay, that this particular manufacturing contract initially starts with when the client, the buyer is issuing a purchase order. So that is your point of commencement. So say that point of commencement is X, which is the day of issue of the purchase order. Then you will have various clauses which will say that once the purchase order is issued, then it should be, then within 5 days, it should be communicated for acceptance. Then after that, within 10 days, if there are any changes, then the PO should be referred to, and the either party can make the changes. Then after that, you have that from the date of issue of this, the buyer will come down for an inspection of the material, or they will have a manufacturing. During the manufacturing, they are going to come for an inspection. So all of these points, all of these days are preliminary going to start from an X date. Once you are able to identify that X date, you start timelining yourself as to X plus 5 में क्या होगा, X plus 2 में क्या होगा, X plus 3 में क्या होगा. So this is about the basic timeline determination. And if you are able to identify the timeline, you are halfway through. And not only that, but you will impress your seniors and all of your clients when you are able to show this to the client. And if you're doing this in, say, for example, you have a flowchart format, then nothing like it. It takes the deal away from, nobody can take the deal away from you, and you're through. Again, here, it's important that we understand the execution timeline. So when we, again, taking the example of a manufacturing unit, we should know that whom we are sided. If we are from the buyer, then we should know that what are the the complications that the buyer would have, and what are his time limits that he has to meet with. And if we are from the sellers, then we should understand what are the contingencies that the seller would have, and what is the aggregate time that he would require for execution of the entire scope of work, plus and minus a few days. So this is very important. Now here I would like to introduce the concept of lead time. Lead time is that particular time that that any organization needs in order to complete a set of work or a set of production for a per unit of products. So identifying lead time will help you, and it will go a long way in being able to negotiate the number of days for both the parties. If you're from the side of the customer, then you know that you may have any obligations, further obligations, either a counter sale to be done, or that you have already committed for supply, something of that kind. So based on that, you would try to, from the side of the client, you would try to press down on the number of days. And if you are from the side of the, say you are from the end of the manufacturer, then you would try that, you would be able to cover all the glitches or all the time limits that are necessary for raw material arrangement and, shipping of the raw material, and during the manufacturing, the number of days that would require, the assembly of products, the packaging, all of those things. So, so far, so clear. Are we through? If I say that I want to have an export of, say, a food item, an FMCG product, what are the parameters that you would discuss? So this is just a discussion. It's not a contract. So anyone from the room can be a manufacturer, and I am the purchaser. I want to take, say, about 100 kgs of a snack from you. I want to buy. So what are the points that you would discuss for until what we have understood on the fourth point? What are the points that you would discuss with the client? Anyone by the raise of hands?
Ma'am, they could discuss by what time do they want the delivery of goods, and at what point they will make the payment.
Correct. But delivery of goods and payment would be dependent on what criteria, according to you? What would be the basic criteria? So now, if you have to buy, let's reverse the position. If you have to buy something from me, say about 1 container of something, and I tell you that I want payment in 15 days, then what would be your counter argument?
The buyer could potentially say something like they will make the payment at the delivery of goods or after it.
Correct. So here comes the question of when the delivery of goods will be made, we will make the payment. So over here, as a lawyer of the manufacturer, you have to ensure that asking for money for within 15 days would be justified or not. What are we asking for? Are we asking for part payment as advance, or are we asking for full payment? Would we be able to make the entire order, effectuate the entire order within 15 days? Where are we to source the material? Do we already have a stock of material or not? These are the things that you would want to understand. And this is called the lead time. So the fifth and one of my very important points is, what are the delivery parameters? Especially, though these are very, very necessary for domestic also, but in international sales, the delivery parameters decide a lot of, they speak volumes about the liability with respect to the product. So now this is essentially for a product sale only. The world has, for the world transaction and trade, they have identified Incoterms, and based on the Incoterms, the party holds it. It decides which party holds the title of the product at which point in the contract. So, for example, there are incidences when the buyer says that we will pick the material from the factory site of the manufacturing. So, when they're picking the material from the factory site, say on the 20th of June, the material is ready. Then on the 20th of June, at the factory site, once the material is loaded inside the vehicles of the buyer, or any other logistic company held by the buyer, the liability of payment starts, and towards the title of the goods for the manufacturer ends, and for the purchaser it begins. Okay, so this is absolutely necessary to understand that at any given point in time, who is going to hold the rights of the goods? If the rights of the good is held by the manufacturer to a certain extent, or say until the port, then the manufacturer will have to arrange for in-transit insurance or delivery from his manufacturing unit to the port. And if it is going to be until the port of the purchaser, then he will have to arrange for insurance until the port of the purchaser. Now, if the purchaser is going to volunteer for custom clearance, then the liability will be his after it has reached the foreign port. However, if not, then again custom clearance and liability until of the product until it reaches the manufacturing unit of the purchaser remains that of the manufacturer, and he has to bear the cost of insurance for everything. Is this clear? These are a few Incoterms. Ex works, FCA. Ex works is when someone is purchasing goods from your factory unit and they are taking it from your factory unit. This clearly discusses whose liability of insurance, or at what point the liability ends, at what point it begins. The title of the goods is necessary to identify, because if there is a loss, then who is to bear the loss? That it identifies that. You could take a screenshot if you like. Plus, this is also available online. If anyone wants me to discuss any of these, please let me know. So can someone tell me at what point would the liability of the buyer begin, in a DDP, delivery duty paid setup, arrangement for delivery?
It's at unloading at destination.
Yes, exactly. So it's easy to identify through this.
Yes, thank you.
So going on, you would also see that insurance is shown to be negotiable at different junctures. However, when we say negotiable, it's not exactly negotiable. It has to be borne by one party only, the party who is going to hold the right. It's just that the party who is holding the right into the product will calculate the cost of insurance per unit and then they will give the quotation. That's it. Okay. Check for legal clauses. The basic legal clauses of indemnity, IPR, liquidated damages, force majeures. These are the basic legal clauses. You should check when they are commencing, what is the rate that they are charging us, if there are any penalties, if there are any delays which are attributable to either parties, then what are the consequences of the delays? What are the termination criteria? I'm sorry, I forgot to mention the termination. What are going to be the effects of the termination of the contract? Who is going to be liable for what extent for the confidentiality of the contract? For how many years? And how they are going to separate? What is going to be the exit point? The exit clause is very, very important. More than entering into a contract, you should ensure that your client has a smooth exit point, because most of the times huge stakes are involved and it's very lucrative for either of the parties, and they forget or they ignore to look at the exit place that they are going to face a complication. And when it does happen, when a dispute does arise, then such contracts are especially the ones who do not have a properly determined exit clause, they go into arbitration. So you should check your for preferences of arbitration, what laws, what is going to be the seat of arbitration, what is the jurisdiction. All of these things are important to understand. Annexures. So most of the time, in fact, 90% of the times, the contracts are made long because they are attached. There are many attached annexures. So do not give them a very conscious thought at the time of reading the contract. Agar jahan clause mein annexure mention kiya hai, if you sit and read it at that point in time only, then remember you are never going to be able to complete the work. So what you have to do is efficiently just read the title of that annexure and mark it. So say if there are 10 annexures, write down in your diary which annexure is for what purpose. Read it separately and then go back to that particular clause which mentions the annexure and just take a contextual reading again, a soft contextual reading again. That way, a lot of your complications will have been dealt with. And the longevity of the contract is not going to affect you at all because most of them are annexures. As I said, the closing point, the termination is the most important. The rights of the parties after the termination until what is the survivable, so what clauses survive the termination of the contract is also more important. It should not be that any financial obligations continue to impose despite, your exit in the contract. And what are the causes of exit? That is also something that you should look into and read extensively. That's it from my side. Thank you very much.
So, Shabnam, should a lawyer prepare a set of questions before reading a contract?
Yes, preferably so. A set of questions that they have, then while they are reading, they should be able to answer it.
Okay. And what about if there are any anticipations, if they anticipate any event, so how can they ensure that the client benefits?
So a contract essentially, especially the ones which are very, very lengthy, are about anticipations and foresight. So a lot of things, practical impossibilities can be covered in force majeure clause. Just say there are many industries who face a lot of shortage when suddenly the demand of the product goes up. So based on that, you can have a reasonable force majeure clause which would identify all of these problems and deal with them. Also, there are junctures where the buyer would impose too many, say for example, let's take this as an example. There could be a setup, an arrangement where the buyer would say that we would work on the X works basis. We would take the material from your premises on our logistic, which is arranged by us, okay? And or it could be arranged by you, but we will pay them. Now, in this particular setup, there are times when the buyer, when they do not have the money at all, or they do not have the money to pay for the products that they have purchased, they will not come and pick up the product, even after the manufacturing is complete and intimation has been sent to them. So there is no delivery over here because the product is lying in the facility, in the manufacturing facility of the manufacturer. So for such things, what we do is we ask them for additional storage charges, or that if it is occupying too much space in our utility, then we would want to shift it to another place which should be borne by you. If something happens at the warehouse or other place that we have shifted, then that again is your responsibility. So all of these things, a foresight is very necessary to identify these problems.
Ma'am, what does the interpretation clause comprise of?
Interpretation clause basically comprises of, if there is a mention of a he, then it should be read with she. A plural stands for a singular stands for a plural. Hence, here, therefore, all of these. So it's basically like a definition clause for very, very frequently used terminologies. I think if you read an interpretation clause once or twice properly, and whenever you are free, not at the time of actually doing the assignment, you would easily skip that part.
The next question is there a distinction between a MOU and an agreement?
No. An agreement also records the basic understanding, and MOU also records a basic understanding, but I refrain from using the terminology MOU because the courts don't appreciate this kind of a title to a contract instead of an MOU, because everything is an understanding only, whether it is a purchase or sale or anything. Even a sale transaction of a property is an understanding, but we still, term it as a sale deed and not as an MOU. So understand the transaction and come with a proper title so that it makes it very clear as to what the transaction is going to be.
Now there's one more question. Do all contracts fall within the ambit of the Indian Contract Act?
So yes, by and large, all of them, except if there has been an exclusion to that effect.
Okay. Are there any contracts that, do you remember any that are not governed by the Indian Contract Act?
So a contract being governed by an Indian Contract Act would be very, very different to assume what is the law that the parties are going to follow in case of a dispute. Okay. So when I personally execute contracts with any of the international bodies, I always guide my client as to what is acceptable. So there's a popular notion that the word penalty is not used in a contract when, especially when I make it, because there have been Supreme Court findings, not judgments exactly, observations that you should not be levying penalties by way of a contract, except if it justifies the damage that has been done to the other party because the breach has occurred. So whenever there is a term of penalty, then we try to remodify it, or if there is a amount which is predetermined. So for example, Malvika is not able to give me particular work, then I will, irrespective of what my loss is, I will take 5 lakh rupees for Malvika. So that becomes unreasonable. So yes, this way we think of it in the line of what is acceptable in Indian Contract Act. However, the jurisdiction and the dispute resolution bodies can be very different.
And the last question is, do rules of interpreting a statute also apply to reading a contract?
So a statute is a far more complicated, frankly, because it is guided by a lot of, very, very small, minute details, I feel. Sometimes the contracts are also with a lot of minute details because they run into thousands of crores of states. So yes, interpretation of a statute could be very well used over here. However, if, you're able to actually apply the iOS, then it makes sense. So I would never go, even when I learned English, I would not go by what English grammar told me. I would go by what I have read and what is, functionally used in everyday conversation. So instead of looking at the rules, just look at how much sense it makes to you.
Is there any closing remark before we end?
So I have this one suggestion from Team PLEA, that if I could give some tips on speed reading, because there are times when you do not have, you don't have sufficient time to read a contract.
Yes,
so you could skip certain sections like confidentiality, because those are standard clauses. However, when you skip these sections, you should know, you should have read it when you have the time. Okay, so continuous repetitive reading, these are very standard sections. Confidentiality is a very standard question. Interpretation is a very standard question. Certain definitions, just say authority ka definition, are very repetitive. So you could look out for things that you have already read in the past and you could take a skip. However, I am not too much in favor of speed reading. I would rather deliver something a little later than be half-hearted about it. Because whenever I read a contract and if someone points it out that, this is not written, and however, if it is stated in the contract, then I might not remember the clause number, but I'm 100% sure that it's written. So I would discourage speed reading. But in case it is necessary, you could skip some standard clauses. Thank you.